This is You and the Law on AM 650. Now back to the show.
Sterling Fox with you on this edition of You and the Law with David Hobbs and Ian Giroday from Hobbs Giroday in Vancouver. HobbsGiroday.com, by the way, the website for this law firm that specializes in estate litigation. And we're talking about wills and estates and the sort of work that you, David, and Ian do. Estates litigation. This clearly means that not all of these wills are resolved as automatically as one might expect. What percentage of wills actually just sort of goes through uncontested, exactly the way they were written? Everybody's pieced off, everybody's happy, everybody goes home with a smile on their face, versus the sort of work that you do?
Well, it's a difficult question, Sterling, because, of course, the ones that are uneventful, we don't deal with. We're only dealing with the ones that are eventful. But I think a significant percentage of, in today's modern world of estate planning and families have circumstances within the families that trigger these problems that occur in estate litigation.
Absolutely. Distribution of the estate, of course, is the basis for wills variation and a lot of estate litigation. Ian, you mentioned something in the last segment about, we have wills that are written in many cases to reflect cultural realities that from the old country, for generations, that's what you did. When you died, the father left everything to the oldest son. Well, this is the new country. This is a different milieu. And maybe, just maybe, Canadian courts don't care as much about that old country way of doing things. Or do they? What do our courts, how do we handle those cultural wishes?
Right. So certainly the wishes of the will maker, the testator, is an issue that the court has to grapple with in any wills variation claim. They have to pay some mind to the fact that that's the way that it's his or her estate, and that's
right.
The way they wanted things to go.
Right.
So that's one factor. But another factor is, this person had 5 children and left a significant estate, say $1 million, and only one of those 5 is set to inherit it under the will, and the reason for it, as we've just discussed, it may be something like that's just the way it's.
That's right.
That's the way it's been from the old country. Our courts look at wills variation through the eyes of legal and moral obligations owed to spouses and to children, and what those obligations are vary depending on who you are and what the circumstances are. But by and large, if there's a striking difference between people that fall within the same category, say 5 adult independent children, only one of whom inherits the bulk of the estate.
Right.
The court's going to have a close look at the testator's, the will maker's reasons for that, and whether the reason is valid, rational, true, and whether it's in compliance with today's society.
Sure. So now, would that case have been brought to the court by one of the 4 other children who's going, wait a second, this is Canada, it's 2013. I don't care what great-great-grandpa did back in the old country. I want a piece of the action. I'm as much entitled to the outcome of this estate as my older brother who gets everything. Not fair. I'm going to Hobbs Giroday.
Sure. That's exactly the type of person who'll come in the door, and sometimes only one of the 4 will go forward with a claim, and sometimes all 4 of them will, and sometimes more than one of the 4.
Well, now what happens, David, in a case like this where, say, you've got 5 kids. Dad left everything to number 1 son. One of the other 4 is not impressed and decides to come forward and have a little chat with you fellas. But suppose now, of the other remaining siblings, a couple of them are going, hey, look, you've known your whole life that Dad's going to do this. That's the way his father, his grandfather, etc., have done it forever and a day. You've known since day one that your big brother's going to get everything and, deal with it. Suck it up and deal with it. So then what? What happens when you have some children who aren't recipients going, that's okay with me, I've been prepared for it all my life?
Well, each child has their own unique claim. So if one child feels that the will is not fair to that person, then it doesn't matter that the other children choose not to make a claim or accept the outcome. Each person has a unique claim, and that gets into the uniqueness of the individual. So if some of the children are very well off, financially well off, and one child isn't, the fact that that one child is not financially well off is a relevant circumstance in what is just, adequate, and fair in the distribution of the estate. I think of a case we did years ago where there were 4 children, 2 daughters and 2 sons, and the old gent decided to and was moved into the basement of one of the daughters.
Okay.
And during the time that he lived in the basement, his estate gravitated towards that daughter, such that when he died, there was a terrific imbalance of the distribution of the estate. And of course, the 2 sons didn't feel that was fair. They had no reason to believe that their father would distribute the estate unequally between the children. And then all the dirty laundry comes out at that point as to how these things happen, why they happen, the finger pointing between the children as to, in the self-serving sort of way of why I should get more and you should get less because you did this or you said that or whatever. And that's the unfortunate, unpleasant drudging up of all the history of the family to figure out what the balance should be, why the imbalance exists, and what the background is to that.
Interesting.
Yeah.
Now, Ian, you were just watching David and nodding because obviously this is the sort of family disharmony that ends up with a lot of these cases being contested, and you seeing a lot of these unhappy people as clients. But there's just watching your face as David was going through the family dynamic aspect of all of this. There's a ton of emotion involved here, isn't there?
Well, sure there is. We all like to think that our parents love us equally with our siblings, for example, and may choose to treat us equally or at least proximately equally under their wills and so forth. But often they don't, and that's why we have people coming in the door unhappy with some estate planning that's been done.
Well, the Smothers brothers used to make a joke of it, right? Tommy was always, Mom always loved you the most to Dick. And it was funny. And it was part of their shtick. I mean, it was part of their act. But, it's not funny when years after the fact, they're both sitting opposite you, and one has received the bulk of the estate and the other has received next to nothing, and proof positive that Mom loved you more. Well, that's not funny anymore, especially for the short end of the stick person, is it?
It's interesting, Sterling, how the imbalances and the inequities can arise. The example I gave you would be a child who has close proximity to the parent, and
the caregiver,
and
right?
can work that relationship 24/7. Another example can be an elderly person. Their spouse passes away. They've been married for 40 or 50 years. The 2 of them have been, an item their whole lives, and there's that huge void for that survivor.
Yes.
And so the void is so massive that just about anybody can fill the void. It could be anyone bringing cookies to the person. It could be the person out mowing the lawn. It could be the next door neighbor. It could be anyone. And why is that void so easy to fill? Because the person's so lonely and it's such a massive void that they're inviting to anyone.
Sure.
And willing to share with that person, to the dismay of their children, for example, who can't believe that a relationship that's only a year in length, say from the death of that person, becomes a relationship that receives the entirety of an estate.
Right.
They don't see how that happens. It can be caused by mental health issues where people are becoming frail and their decision making is starting to get a bit askew. It can be, sometimes there can be a person, but it's not really them, it's someone behind them. So a person can start living with another person, but it can be the children of the new move-in who are the drivers of trying to become part of the estate planning of that, of the first to die. And so these potentially dysfunctional situations can come in a lot of forms. and resulting in these imbalances that occur.
Is a trial in which a will is contested and a variation, a change, is requested, is that trial usually conducted in front of a judge or a judge and jury?
Usually a judge. In our system in British Columbia, we don't have that many civil jury trials. It's a much more prominent phenomenon in the United States.
Okay.
But here we don't have them. I don't think there's a prohibition against a jury trial for a wills variation action. You could have a jury trial, and a jury might be a good choice. There's issues about juries, choosing them, costs and time issues and other things. But maybe a jury would be a good listener to a story about a family that has fallen into a stressful circumstance.
Well, that's it, and Ian, that's precisely why I just asked about the judge and the jury, because we're talking now, as David has just described it, especially in a late marriage, a late in life second or marriage, we're talking about influence now. We're talking about parties that end up influencing the person that writes the will. Is it part of the job of you lawyers to identify those people who may have unduly influenced the will writer?
Yes. Undue influence is a cause of action. It is sort of a lawsuit in and of itself, Sterling. If we can actually prosecute a case where we can upset a will, make it invalid on the basis that it was procured, brought about by undue influence.
Interesting. So the whole will gets tossed then?
Right.
Wow.
In a wills variation setting, we're not saying that the will before the court is invalid. We're not saying that it was procured by undue influence.
Okay.
But certainly the circumstances by which that will was made, how did it come to the point where the caretaker or this Johnny-come-lately
gets all the marbles,
is the main benefactor under this will?
Yeah.
What circumstances led to that? Did it upset a long-standing series of wills where those who you'd expect to be to benefit, the children, assuming the spouse is gone,
right,
suddenly they're not very prominent in this latest will? Why is that? And maybe it doesn't rise to the level of undue influence so that you upset the will, but it can certainly be a factor that the court will be looking at in a wills variation claim.
Let me just follow that for just one quick second, because earlier, Ian, you talked about, when we were just starting off, you said that in answer to my question about why such a high percentage of us don't have wills, you described that, well, in fact, in law, there's a law that kicks in and acts as a will in the absence of one. And I'm describing it poorly, but that is the case, right? So if a will gets tossed out of court because of undue influence as the reason, does the whole estate then revert back to that template that the government has in place for people who die without wills? Is that where it goes?
No.
Oh, okay.
Unless that's the only will in existence. If there's an earlier will, you go back to the next most recent will.
Oh, okay. Oh, all right.
You remember, all wills usually begin with the words, "I hereby revoke my previous will." So when you kill that will, the revocation of the earlier will falls, so it is no longer revoked.
Oh, I see. So whatever you had before is now the deal of the day.
Yeah, unless something else revoked the will, like a marriage or something like that, intervening.
It's fascinating stuff. And we haven't even got to the whole matter of families. Ian, you've just alluded to that. We better take a break here because I want to talk about blended families, and we've talked a little bit about some cultural influences that may come to play in the outcome of wills and whether or not they become contested down the road. But families, in 2013, the definition of family in Canada is certainly different from what it was, say, a generation ago, to say nothing of back in 1953. We'll continue on You and the Law here on AM 650 with David Hobbs and Ian Giroday from hobbsgiroday.com.
There's more of the show still ahead. This is You and the Law on AM 650.